Welcome back to the Constitutional Clarion. This time I'm going to talk about the second legislative response to the High Court's judgment in NZYQ. And what it did was put in place a preventive detention regime in relation to that category of affected people, which were the people who were unlawful non-citizens who were unable to be continued to be detained because they could not be deported in the reasonably foreseeable future. The catalyst for this legislation was a paragraph towards the end of the High Court's judgment in NZYQ, in paragraph 73, which pointed out that the order for the release of the NZYQ would not, quote, prevent detention of the plaintiff on some other applicable statutory basis, such as under a law providing for preventive detention of a child sex offender who presents an unacceptable risk of reoffending if released from custody, unquote. Now, it's important to note here that the court did not say, despite some politicians asserting it did, that the Commonwealth Parliament has a power to enact this kind of preventive detention scheme in relation to child sex offenders. What it said was that the order releasing NZYQ would not prevent his detention under another valid statutory basis. Now, it's important to acknowledge here that when the High Court made this comment in its judgment, it was effectively recognising that there are already schemes in existence at the state level in relation to the preventive detention of sex offenders. Now, whether such a scheme could validly be established at the Commonwealth level is another matter altogether, and not one upon which the court actually gave any view. Nonetheless, after the High Court handed down its reasons in NZYQ, the Commonwealth Parliament moved immediately to enact a preventive detention regime. Now, it was tacked on to an existing bill that was already in the Parliament, so it has the rather peculiar name of Migration and Other Legislation Amendment, Bridging Visas, Serious Offenders and Other Measures, Bill 2023, if anyone was trying to find it, because heaven knows you wouldn't be able to guess otherwise. Anyway, it was passed by the Parliament on the 6th of December 2023 and it received royal assent the following day. Now, what this bill does, amongst a number of other things, is add a new part 9.10 into the Commonwealth's Criminal Code. And that part is entitled Community Safety Orders. And it permits a state or territory Supreme Court to make a community detention order, so that's the one that puts you in jail, or some kind of detention facility, or a community safety supervision order, so that's a bit like what they're already doing with the visa conditions, so, you know, all those sorts of restrictions on your movement, electronic monitoring, curfews, that sort of thing, in relation to adults who are non-citizens who have been convicted of a serious violent or sexual offence which was punishable by a prison sentence of at least 7 years, and for whom there is no real prospect of deportation becoming practicable in the reasonably foreseeable future. Now, the reason I pronounce punishable in that weird way is that often people don't realise that we're not talking here about the actual sentence a person got. That sentence could have been 2 months in prison. It's about the category of offence. So if that particular offence for which they were convicted was one where you could have had a maximum sentence of 7 years or more, then that's the category of offence that allows the triggering of these kinds of orders. So to that extent, it doesn't relate to the seriousness of the actual offence that you committed because it doesn't tie to your particular sentence. Okay. Now, the order may only be made if the court is satisfied to a high degree of probability on the basis of admissible evidence that the offender poses an unacceptable risk of seriously harming the community by committing a serious violent or sexual offence. The court must also be satisfied that there is no less restrictive measure available under the division. So that means going down from a detention order to a supervision order, or indeed in relation to the visa conditions, which would be effective in protecting the community. So that gives the court the flexibility to say, okay, well, we don't think that given the level of risk, it's necessary to have you detained in jail. We think that it's adequate that you've already got these restrictions on you, either in your existing visa conditions or that you need some slightly higher level of conditions which could be done under a community supervision order. So it gives the court that sort of flexibility. Now, the order can be made for a period of up to 3 years at a time, and it must be reviewed annually. Part 9.10 is modelled on the existing preventive detention regime for terrorism offenders in Division 105, capital A of the Criminal Code, and it contains all the discretions and rules of fairness and evidence and those sorts of things that you would expect to see in relation to judicial proceedings. So to that extent, it's probably much less vulnerable to a Chapter 3 challenge than the imposition of the visa conditions, which I think is more vulnerable in the High Court. We also know that the High Court has previously, in a case called Thomas and Mowbray, upheld the constitutional validity of another division, that's Division 104 of the Criminal Code, which allowed the courts to make what were called interim control orders for the purpose of protecting the public from a terrorist act. Now, the law there required the court to be satisfied in making its order that the obligations it imposed on a person were reasonably necessary and reasonably appropriate and adapted to fulfilling the purpose of protecting the public from a terrorist act. Now, the High Court accepted in that case that such an order was judicial in nature, which is essential because courts, of course, are confined to exercising judicial power, and that it did not breach the limb principle, even though the court was not acting to punish guilt for a criminal offence. It was actually detaining people in relation to things they might do in the future. So there was an argument that that was something that was non-judicial in nature and couldn't be done by a court. The majority, however, pointed out that historically the courts have restricted the liberty of people on the basis of what they might do in the future. And they've done that by issuing an apprehended violence order, for example, or also imposing bail restrictions on people, and orders to keep the peace and those sorts of things, particularly in times gone past. So their honours did accept that this was something that a court could do. However, they did note a distinction that in this particular case it was control orders, supervision orders that they were dealing with, not putting people in detention by the state. And they said, well, that might be a different matter. And that different matter is what's in these preventive detention orders and indeed in Division 105A. But since then, there's been a lot of cases that have dealt with preventive detention, including detention in prisons, as well as those sorts of supervision orders. In the case of Vella and the Commissioner of Police, which dealt with a state law about preventive detention, a majority of the High Court upheld the validity of serious crime prevention orders, which permitted the detention of persons where a court is satisfied that the person has been involved in serious crime-related activities, and there are reasonable grounds to believe that the making of the order would protect the public by preventing, restricting or disrupting the involvement by the person in serious crime-related activities. Now, the majority thought that there were good reasons why such powers, if they are to exist, should be exercised by the judiciary rather than the government or the parliament. Indeed, the majority had said the same thing in Thomas and Mowbray. They considered that it's better for the affected person whose liberty is being limited to have those protections of procedural fairness, legal representation, written reasons, and the ability to appeal. So all those sorts of protections that are built into the judicial system that are not otherwise necessarily there are really important. And that's one of the reasons why they justified that a court should do this sort of thing. But the case did show that some judges at least are quite uneasy about the exercise of this role. So in particular, Justices Gageler and Gordon were concerned about the use of the judiciary to do what they described as the work. They didn't say the dirty work, but I think they sort of meant that, to do the work of the legislature and the executive. Justice Gageler said that there were stark differences between the law that existed in relation to the Vella case and the law that had previously been upheld by the High Court in Thomas and Mowbray. He thought that the Thomas and Mowbray law did contain adequate legal standards and specific criteria, but that these were lacking in the law in relation to Vella. And both of these judges concluded that the law was not compatible with the institutional integrity of a court. So you can see that the whole issue of preventive detention and whether or not it's appropriate to be done by a court, while it has been upheld by a majority, remains contentious. And that can be problematic when you meet challenges in the High Court. The other point to make here is also that there are significant differences between this new Part 9.10 and the existing Division 105A that concerns the terrorism regime. First of all, the terrorism regime in Division 105A relies on the Commonwealth's legislative power to make laws with respect to defence in Section 51(6) of the Constitution. Well, that's not going to support a law with respect to the preventive detention of non-citizens. So there the Commonwealth's going to have to rely on the alien's power in Section 51(19) of the Constitution. But it's unclear whether the scope of the alien's power extends this far beyond issues of allegiance, permission to enter the country, and deportation from the country, which is what the alien's power is normally used for. Now, there have been some mixed views about this again in the High Court. Some justices have regarded the alien's power as what's described as a person's power, and that is a power to make any law whatsoever with respect to that category of persons. Other judges have regarded it as applicable only to matters concerning the entitlement of people to remain in Australia and their deportation. So it has to have that connection to the status of being an alien. So, for example, Justice Gordon, in the Lim case itself, the one that we've spoken about a lot here, saw the alien's power as confined to laws respecting matters that are sufficiently connected to the person's status as an alien. Her Honour said this: a law imposing special obligations or special disabilities on aliens, whether generally or otherwise, which are unconnected with their entitlement to remain in Australia and which are not appropriate and adapted to regulating entry or facilitating departure as and when required, is not, in my view, a valid law under Section 51(19) of the Constitution. She went on to say, a law of that kind does not operate by reference to any matter which distinguishes aliens from persons who are members of the community constituting the body politic, nor by reference to the consequences which flow from the non-membership of the community, and thus, in my view, is not a law with respect to aliens. Now, in contrast, Justice McHugh, in the Lim case, considered that the alien's power can be validly used to impose burdens, obligations and disqualifications on aliens which could not be imposed upon citizens. Now, that's of course subject to any other kind of constitutional constraint, like Chapter 3 of the Constitution and the Lim Principle. Now, the alien's power is not a particular area of expertise of mine, I have to say, so there might well have been some kind of definitive authority, which the High Court might decide it would not be prepared to reopen. That resolves that question. But absent that, I think it's at least arguable that the alien's power does not support a preventive detention regime in relation to offences that are unrelated to the status of a person as an alien and their admission or removal from the country. In other words, if those people are a risk to the community, they have to be treated under a law that deals with everybody who's a risk at the same level of risk to the community. Now, the alien's power would also be unlikely to support Part 9.10 to the extent that it applies to non-citizens who are non-aliens, as identified in the rather controversial cases of Love and Toms. So you might remember there the High Court recognised that certain people were Indigenous Australians, even though they weren't actually citizens of Australia. They still met the relevant test for being Indigenous Australians, and that meant that they could not be treated as aliens. So if they couldn't be treated as aliens for the purposes of deporting them, then presumably they cannot be treated as aliens to attract the alien's power in order to be held in preventive detention under this particular regime. Another distinguishing aspect of Part 9.10 is that it only applies to non-citizens and does not apply the same preventive measures to Australian citizens who've committed the same crimes and have the same risk profile. Now, this raises a question as to whether the scheme is really for the purposes of community protection or actually for punishment. If community protection were the main concern, or the primary concern, then non-citizens and citizens alike would be dealt with in the same way to the extent that they raised the same levels of risk and concern of the need for the community to be protected. And therefore you would be doing that under a state law. Other differences from Division 105A include that Part 9.10 applies to persons convicted of offences in foreign countries under foreign laws. And that, of course, raises concerns about whether or not those proceedings might have been unfair or whether they were convicted on trumped-up charges that were laid for political purposes. Could an Australian court have any faith in relation to the validity of those convictions? So that might be a concern. And Part 9.10 also applies to persons who have served their sentence and been released into the community, potentially for many years. Now, whether these differences actually affect the validity of Part 9.10 would, of course, be a matter for the courts to determine, if there's a challenge to the scheme, of course. But it may be, in fact, they're actually just treated as relevant factors in a judge deciding whether or not to grant the order. So, for example, if a person has been released into the community for a significant period of time and has not done anything wrong, it's going to be much harder to establish there is such a high level of risk that they need to be detained under this scheme. All up, this new regime is probably valid, at least to the extent that it is closely based on existing regimes which have taken into account previous cases. But we do also know that at least 2 members of the court have been very wary about such preventive detention regimes. We also know that the composition of the court has changed significantly in the last couple of years. And finally, we know that the High Court in the past has picked up on really small differences, like in one case, the fact that there was no obligation on the judge to give written reasons in relation to making a decision, and said, well, that was enough to tip the whole thing over into being invalid. So given all of that, there is still obviously a risk that if it was challenged, that this regime might be struck down as invalid. Now, this risk is also heightened by the speed at which this legislation was passed, because it left very little time for for those drafting and passing the legislation to consider those relevant differences and how to deal with them in this legislation. And also, we need to consider the very aggressive political rhetoric at the time, which pointed to a desire to punish as well as a desire to protect. So all of these things might well have an influence on the legislation if it is ever challenged in the High Court. Well, thank you for watching the Constitutional Clarion. I hope you feel better informed about this particular legislation and this preventive detention regime, and I look forward to seeing you next time. Goodbye.